It is the voice of Indiana County. It's WCCS 101.1 FM, AM 1160 and WCCSradio.com. Indiana County District Attorney Bob Manzi is with us, and he and I were talking a couple of moments ago. Never did get to what we wanted to talk about today on the program. We'll figure that out together right now. Our conversation presented by Marcus and Mack, voted best law firm and best personal injury lawyer 3 years in a row in the Best of Indiana County contest. Visit them online at marcusandmack.com. Good morning.
Morning, Todd. How are you today?
Wonderful, wonderful. It's a busy time of year for a lot of folks, sort of like the beginning of September, even though it's still summertime and people are still running around in shorts and T-shirts. It seems like it's a transition, doesn't it?
It's getting to be, but it's still summertime, so I'm hanging on to summertime.
There you go. There you go. That's not a bad idea either. So around the courthouse and around your office, I know that we get toward the final quarter of the year and we begin to think about, okay, what are those court cases that have been languishing, and we've been waiting to hear about this one or that one. I think the court backlog is pretty well taken care of now from the pandemic, is it not?
Yeah, we're pretty well through the backlog. I mean, our county ran along where just about every other county was. In a lot of cases, we were doing better with our backlog. But we have a number of trials scheduled this month and next month through the end of the year. Mm-hmm. Really, by the time we're through the end of the year, I think we'll be completely over it. But we still have some serious cases. We have the Terrion Gates trial that'll be it's scheduled for this month. We have Laura Brown, Jackie Kaler, Charlie Mason. We have a number of cases scheduled to go to trial this month. Next month, we have Joshua Brink, which was a DUI homicide. Patrick Walker is a DUI homicide. So still a number of large cases to get through by the end of the year, but our numbers are doing really well.
One of the things we lose track of until they show up on the court docket sheet is the appeal process. Some high-profile cases that we were paying a whole bunch of attention to 3-4 years ago that were finally through the court system, sentences pronounced, and people were sent to prison. Those come back around, and it's almost as if a case is never completely put to bed in a lot of these cases, and particularly in the homicide cases. They drag on through the appeals process, and you can't just put them to bed once the case is completed.
Oh, absolutely not. I mean, even in cases where there's a guilty plea, that doesn't guarantee that a case is finished. I mean, our office just yesterday won an appeal in which a defendant had pled guilty and then was, I believe, trying to game the system, realized he was going to go to jail, tried to withdraw his plea. He wasn't allowed. And then he was sentenced and sent to state prison. And the appellate court reviewed the case and said what we did was correct and what the court did was correct. Our judges take a great deal of time to ensure that the laws are followed, that all the proper steps are taken. But we're still fighting the Brady DiStefano case, which was a guilty plea. That wasn't even a trial. Taylin Edwards, who was part of the Dilltown murder, she entered a guilty plea and was sentenced to life, and then 45 days later filed a motion saying her attorney was ineffective and is trying to withdraw that plea. So cases, even if it's a guilty plea, there are times where, we still have to continue doing post-trial motions and appeals, which is why it's important that when we work cases, we take the time, we do it right, we do it well, because we don't want to have to do it a second time.
That's become more common in recent years, the idea of a guilty plea followed by an attempt to work backwards through the system and find a way out of it. And it's an interesting approach. 5 years ago, we might have said it's an odd approach, an odd way to go about it. But is that a process of the fact that going through the original court process, it was done well enough and done so well that they can't see through the traditional means of appealing a sentence? They can't see a way out. So let's do the guilty plea and then work our way back to it.
Well, I would say it's very case dependent. There's times where a defendant is kind of facing the juror and says, okay, I'll plead guilty, sentencing scheduled later on, because the judge wants to have a pre-sentence investigation, have all of the information before him or her that is necessary to do a proper sentence, the sentence guidelines that are promulgated through the Sentencing Commission, et cetera. And then now that that person's not facing a jury anymore, and they see what type of sentence they're probably facing, then they're trying to backpedal. So really it depends upon who it is and what game they're trying to play.
It's almost predictable that the first thing they're going to do is change attorneys and then claim ineffective counsel. And then as the process gets lengthened and extended, eventually it gets down to the point where I'm going to represent myself and finally get through this. And that all carries a cost to keep this process going. And the county has to bear that cost, doesn't it?
Oh, absolutely. And you know, what you see is exactly what you said. They claim their first attorney didn't talk to them or didn't do a number of things, that they claim, hey, I didn't understand what was going on. But then we look at the transcript and we went over everything on the record and shows that, no, they were told what was going on. They did say they understood. Then they go to a second attorney and really they say the same thing. And a lot of the defense attorneys that practice in here, they do a really good job documenting everything in their files so that when those claims of being ineffective come up, they're able to easily defend them, you know, to show I've talked to you here and there. We went over everything. We have a written colloquy that goes over your rights. We have an oral colloquy in court on the record. So many times when they claim that the defense attorneys are ineffective, there's no finding of them being ineffective because they're doing their job.
In a jury trial, the appeal process, I don't think a whole lot of folks have an understanding of how the appeal process works. When you get to the appeal, it's not, I'm hoping a different jury is going to interpret what was said in court differently. The appeal is most often based upon, did the court do something wrong to allow this to be admitted into evidence? And if I get that kicked out by an appellate court, therefore that taints the rest of the whole process, correct?
Absolutely. It's, you know, when you see an appeal come up, they're going to try to argue a number of different things. Some things we anticipate with just about every appeal, basically a generalized, hey, everything was wrong, everything was bad. Even if you believe all the evidence, you shouldn't have found me guilty. But, you know, what they really try to do is target specific pieces of evidence or testimony to say that shouldn't have gone in, or I should have been allowed to bring that in, and therefore I deserve a new trial. And what the courts will look at is what the law is, whether it was an abuse of discretion or not. And many times there's a legal doctrine of harmless error, basically saying, okay, maybe that piece of evidence should or shouldn't have gone in. However, it was so minute and the other evidence was so overwhelming, you don't get a new trial because of this one little technicality. And they maintain the conviction. So, but yeah, that's the goal is, you know, I call it throw the spaghetti against the wall and see what sticks.
Yeah. So we've been talking inside the courtroom. In the case of building a criminal case for presentation in a courtroom, that's where you have to be really, really thorough in the investigatory process. Are there ever times when you say that evidence really is damning evidence, however, I know what the problem it's going to have in court will be, and therefore I'm going to try to find another way, and I'm going to try to avoid using that piece of evidence unless absolutely necessary. Do you ever come up against that thought?
Well, certainly we'll come up with, you know, in the investigation part of the stage, which is why I prefer to be heavily involved in charging decisions, looking over the investigation to see what we have and don't have, to be able to ask them to investigate a different part of a case. But ultimately, the evidence is what it is. Very rarely do you have a case, especially when you have civilian witnesses who are not used to testifying in court, that are victims of a crime. It's a very shocking experience, so you're not trying to remember it the way that a police officer is trying to remember things during an investigation. And what we do is we try to build out every which way. So even if we have a piece of evidence towards one crime, we want to see if there's other evidence towards a crime. Because if we have three pieces of evidence that support one charge, it's better than one. And ultimately, we want to find out the truth. You know, there's times where we have people come to the police departments, then they make an accusation. Our goal is not a conviction. Our goal is justice. And sometimes that means someone has made a report to the police, and we were able to prove them wrong. You know, a person making a report to the police does not come to the police as, we trust you blindly. We want to get every piece of evidence we can because we want to get to the truth.
He's Indiana County District Attorney Bob Manzi joining us today. You mentioned a couple of moments ago when you're talking about current cases, a couple of homicide by vehicle, DUI crashes, and defendants that will be making their way into court. That's obviously the most serious of the DUI crimes, but DUI remains just way out of control in terms of the number of cases that are out there, the number of people that are taking upon themselves to get behind the wheel of a car after they've been drinking. This is the most serious consequence. Somebody gets killed. And as horrible as that is, just the idea of somebody being out there inebriated and behind the wheel of a car should be enough to scare people into not doing that sort of behavior, but it's not.
It does, and you know, I want to give all the credit due to our local and state police, police departments in Indiana County. They do a phenomenal job in their investigations, in their detections of DUI drivers on the road. So a lot of the times our numbers look the way they do because our officers are doing a really good job identifying DUI drivers and getting them off the street before something worse happens. But yeah, we talk about, and we've talked about for years here, about get a driver, get a friend to drive you home. If you don't have one, make the choices necessary to, I'm not going to drink tonight because I don't have a driver. We continue to deal with medical marijuana where people feel like if I have a medical marijuana card, I'm allowed to drive. Well, in Pennsylvania, if you have marijuana in your system, you are per se DUI. Your reaction times are much slower, and you are per se DUI. So, we always encourage people, you don't want to be in a position where not only are you under a DUI arrest, but you've hurt yourself, you've hurt somebody else. And many times the person that is killed is the passenger in their car. Yeah. It's not a stranger, it's a friend. And the idea, there's this idea that it's the person who is just completely inebriated. They've been drinking all day. It's not. There's many times where that DUI driver has a relatively low BAC. Mm-hmm. They're over the limit, but it's not that they can't even stand. It's the person that had 3 or 4 beers and then they go home. Their reaction time is much slower, and they've caused a DUI accident that killed somebody or killed their friend.
Yeah. Yeah, you're thinking about, just a deer jumping out in front of you. If your reaction time is altered, then you've caused something by your drinking.
Sure, absolutely.
All right. Well, that's a heck of a way to end this segment. He's Indiana County District Attorney Bob Manzi. Thank you for the visit.
Thank you. I always appreciate it.
It is the voice of Indiana County. It's WCCS 101.1 FM, AM 1160, WCCSradio.com. Boomer Sports next. Jake is here in the newsroom.